Please.
Welcome to this second video inside the International Tax Law course of the University of Trento, and in this one we are going to analyze an ECJ case regarding free movement of workers. Excuse me. The ECJ case that appears in 1995 was related to preliminary ruling presented by the German Federal Fiscal Court, in which the main question was the interpretation of Article 48 of the treaty establishing the Economic European Community. And nowadays, this one is this free movement of workers is inside the Article 45 of the Treaty on the Functioning of the European Union. The main aim of this preliminary ruling was the interpretation, as we have said, of this free movement of workers in the case of the legislation of the Federal Republic of Germany on income tax, and in particular on personal income tax. The main actors of this problem were the tax office, a German tax office, and Belgian national called Roland Schumacher. And the problem was the way in which this Schumacher income was treated or was taxed in Germany. In Germany, as in different member states of the European Union, personal income tax law distinguishes between resident and non-resident regarding the way in which ones and other are taxes. For those residing in Germany, they are taxing for their worldwide income. So for the incomes that they get inside Germany, but also abroad. On the contrary, for those non-resident, Germany taxes them just for the income that they get inside Germany. So for the sort-based income. In the first one, for resident, we can call it unlimited taxation, and in the case of non-resident, we can call it limited taxation. The way in which personal income tax works in Germany, and also, as we have said, this mechanism is also used in other countries in the European Union, but also at international level. The way in which the personal income tax applies is with a kind of withholding tax applied by the employer that was deducted, the amount of the future tax that the employee has to pay is deducted in advance by the employer. For calculating this deduction in advance, this kind of withholding tax, inside the German legislation, at least in the moment in which Schumacher was working there, we have different categories of taxpayers. In the first one were single persons, and in the third one we find marriages, so persons that were exposed with other German persons. The main advantage of this third category, category 3, is the application of what called as a splitting tariff. And this was a system which was followed for eliminate or reduce the progressive effect of taxation. So for singles, category 1, and for couples, category 3, with this split system that the functioning was very simple. the German state sum the income of each part of the couple and later divide it into two parts, equal parts, for reduce, as we have said, the effect of progressive taxation. The problem was that this category 3 wasn't able for those that were not resident in Germany. So it was just applicable for the resident in this country. Focusing on the special situation of Schumacher, we can say that Mr. Schumacher has always lived in Belgium, so he was a Belgian national with his wife and their children. After first working in Belgium, Mr. Schumacher was employed in Germany, and although he continued to live in Belgium with his family, Mr. Schumacher's wages have been the household sole income. So his wife didn't work anymore. He was working in Germany but living in Belgium. According to the double taxation agreement between Germany and Belgium, salaries and income from labor was taxed in the place in which the work was done. So in this case, Mr. Schumacher has to pay his taxes in Germany, excuse me, because he works in Germany although living in Belgium. Taking into account that Mr. Schumacher wasn't a resident of Belgium, he, although being spouse, he was treated as a single person for taxes purpose. Knowing this situation, now we are going to follow the fourth step system taken into account by the ECJ in order to discover if there was a restriction of any of the four fundamental freedoms, and in this particular case, to the free movement of workers, the possibility of work in another country different of your country of your nationality country. If we read the case of the ECJ in this Schumacher case, first we can find the comparability and discrimination or not, discrimination or restriction analysis. The ECJ understands that tax benefits that are granted just to residents of a member state, in this case for those residents of Germany, may constitute indirect discrimination by reasons of nationality. As we all know, discrimination arises when one member state, in the case of the European Union, one member state applies different rules to comparable situations to different, this discrimination or this restriction occurs when we apply different regulation for comparable situations. So as we know, in order to do this exam of comparability or discrimination, we have to compare a cross-border situation, that was this of Schumacher, resident in Belgium but working in Germany, with a similar internal situation. So a resident of Belgium. The ECJ pointed out that in general, in the field of direct taxes, the situation of residents and non-residents are not comparable. Why? Because those residents are able to enjoy the expenses of the public sector inside its country. So if we are resident there, we can go to parks, we can use health system, we can use also education system, and maybe those non-resident are not using these public services. So in general, the ECJ understands that in the case of a personal income tax, an income from labor, salaries should be taxes in the state in which the work is done, as the double taxation agreement said, but the expenses, the personal allowances, the social security contributions has to be deducted in the resident state. So the state that should ensure the application of those expenses is the resident state. This is the general opinion of the ECJ. So the fact that the member state does not grant a non-resident this tax benefit, the application, the deduction of these expenses is not, it cannot be considered discrimination or a restriction. But in this particular case, the ECJ understood that taking into account that Schumacher does not earn anything in his resident state because his family didn't work anymore there, and the income get by Schumacher was just in Germany and not in Belgium. In this case, is the source state, Belgium in our case, the one that has to take into account the general ability to pay of this natural person called Schumacher. So to sum up, in general, the ECJ understands that in the field of direct taxation, personal income taxation, resident and non-resident are not comparable. But in this situation in which the resident state cannot take into account the personal circumstances of the taxpayer, personal allowances, social security contributions, and so on, is the source state the one that has to ensure the application of the deduction of these expenses. Once we have discovered that in the first and second step of the analysis of the ECJ, we have discovered that there is a restriction. The second step, as you remember, is to identify if there is or not a justification cause. For the German fiscal court, was proposed the possibility of taking into account two justification causes. The first one, the cohesion of the tax system. So tax the income in the same place as expenses are taken into account. But for this reason, as we have said, if we cannot tax income in the resident state because we didn't have income in the resident state, is the source state the one that has to ensure the deductibility of the expense for taking into account the whole ability to pay of the taxpayer. And the second cause proposed was the effectiveness of fiscal supervision, that in this case, taking into account that Belgium and Germany has an exchange of information and the possibility of know the situation of the taxpayer, this one didn't apply anymore in this situation. So not having a justification cause, the last step, that is the proportionality analysis, didn't wasn't done by the ECJ. That's all. Thank you for your attention, and see you in the next video. Thank you very much.
Thank you, Carmen.